Ladies and gentlemen, good evening. Thank you very much for being with us for this 74th Lawyers Roundtable. I'm indeed happy to say that LRT is privileged to be actually associating itself with Essex Chambers. It is indeed a matter of prestige for LRT, and I am thankful to Barrister Karishma and Barrister David Brynmor for making this possible. Dear friends, I am pleased to present you two very eminent speakers from 39 Essex Chambers, London, Barrister Karishma Vora and David Brynmor Thomas, QC. I have, in fact, attached their profiles to the email that I sent you. I would not like to take too much time because there is so much to cover within these 60 minutes. I would rather keep time, but I urge you to, at your convenience, if you have not already read the profiles, please read them maybe after the session is over. During the first 20 minutes, Karishma will present on without notice applications, such as freezing injunctions and applications for permission to serve outside the English jurisdiction on Indian parties. In the next 20 minutes, David will speak on anti-suit injunctions, and the last 20 minutes are reserved for an interactive session where David and Karishma will discuss how an English chamber functions. There are many people who have actually asked that this be included because people do not have an insight into how the English chamber functions. So that will be the last 20 minutes. There will be, of course, opportunity for you to ask question and answers. There is no chat facility, but at the end of the session, we will open up for Q&A. Please, all of you, stay on mute, and also please switch off the video because that will help the bandwidth. And at the very end, when the Q&A session actually opens, those of you who want to actually ask questions, only they can unmute and then ask a question. I do hope you enjoy this session. And without much ado, I would like to now hand over to Karishma to make her presentation on without notice applications. Thank you. Sit back and enjoy the presentation.
Thank you. Thank you so much, Mr. Prasanna, if I may call you Pras, as everybody else does. This is my second time at the Lawyers Roundtable, and the first was a good one because we had a sumptuous lunch together with the presentation. I think most people looked forward to the lunch rather than to hear us boring barristers speak, but there we are. I'm going to be speaking on without notice injunctions. There are various types of without notice injunctions. These are also called ex parte injunctions, and that's how I used to refer to them when I was a counsel at the Bombay High Court. And these are an exception to the basic principle that no orders should be made against a party without hearing what the party has to say. The concept of an application being made with or without notice is not the same as whether it should be made on paper or at an oral hearing. So a without notice application can be made both on paper or at an oral hearing. The general rule, of course, is that, as I've just said, a party should be given an opportunity to be heard. And therefore, there are limited circumstances under which a court may entertain a without notice application. And these tend to be only if, as the English court is defined, there are good reasons for not giving notice. So some of the good reasons are that giving notice may defeat the purpose of the application, or it may cause injustice to the applicant through delay or actions that the respondent may take before the order can be made. For example, a freezing order or search orders in cases of intellectual property infringements and so on. The second is if the other side is not yet on the court record. I'm not sure why the English CPR says it. It's quite obvious that in a without notice application, the other side will not be on the court record. The third is the respondent can only be identified by description and not by name. So many of you are joining us from Bangalore, and you would be familiar with search orders with an ex parte search order, where sometimes the infringement cannot be identified to or tied down to a particular party. Very recently, actually, this has been expanded by the High Court in London, and the Commercial Court has granted an order or a judgment against persons unknown. And this has happened in cases of cyber theft. So the judge was willing to entertain and passed a judgment against persons unknown. And it was only when that without notice judgment in its entirety, not even an order, it went all the way through trial. And the judgment, when it was served on the bank, that's when the bank revealed the identity of the fraudster, and a name could have been put to who the defendant should be. So in circumstances such as this also is a good reason for bringing a without notice application. I'm going to focus on 3 types of without notice applications because all 3 are relevant to Indian parties, and since my practice involves very much representing Indian parties in English court matters, I see them almost in every case that I do in court by way of litigation, and this would be together with jurisdiction interim applications. So the first type, the 3 types that I'm going to be speaking about are permission to serve outside the English jurisdiction on an Indian party. The second is permission to serve by alternate means, such as by email or international courier services. And the third is a worldwide freezing injunction, and we'll take each in turn. So dealing with the first, a permission to serve outside the jurisdiction. Now, if a defendant is outside, such as an individual or a corporation in India, or indeed anywhere outside England, then a claimant in the English court must seek permission to serve documents and court proceedings outside the jurisdiction. This is required because it enables a court to exercise control over who may be brought before the English court. And usually the English court will only grant such permission when it's satisfied that there is a sufficient connection with England. There are strict rules that govern the circumstances in which an English court would be willing to grant permission to serve outside the jurisdiction. And these are, if I may summarize them in 3. The first is that the claimant must have a good arguable case that falls within what in England we call jurisdictional gateways. There are about 20 or over 20 jurisdictional gateways, such as a breach of contract was committed within the English jurisdiction, an act or a tortious act was suffered within the English jurisdiction, etc. These are jurisdictional gateways, and the claimant or the plaintiff, as I used to call them in Bombay, must establish that there is a good arguable case that the claim falls within one of these jurisdictional gateways. A good arguable case has been defined as, the old test used to be the better of the argument. So if the claimant has the better of the argument compared to the defendant or the respondent, that's a good arguable case. It has recently changed in an English Supreme Court judgment called Brownlee and Four Seasons. And in that, the test was slightly modified, and a good arguable case is now a plausible evidential basis. So there must be a plausible evidential basis to establish the claimant's claim. The second of the 3 categories that a claimant must satisfy in order to obtain permission to serve outside the jurisdiction is that there must be a serious issue to be tried. So for example, in most of my cases, it would be that the English branch of an Indian bank, such as Punjab National Bank UK or ICICI UK, would have lent money to an Indian party, and the Indian party would have defaulted on it. So there's a serious issue of fact, and that establishes the fact that there is also a serious issue that needs to be tried. So that's a second pronged test that must be fulfilled by a claimant before obtaining permission to serve outside the jurisdiction. And the third is that England is clearly or distinctly the most appropriate forum. This is also called forum non-convenience, etc. So England must be the place where all of the disputes under perhaps more than one contract should be adjudicated. There are two exceptions when a claimant does not need to seek permission to serve outside the jurisdiction on an Indian party or a foreign party. If the contract expressly confers jurisdiction on English courts, such as the jurisdiction clause would say, in the event of default, English courts have jurisdiction. And this is even if it's a non-exclusive jurisdiction clause. So if it says, maybe the DRT in Chennai or the High Court in Delhi also has jurisdiction, but that is it tends to be at the option of the lender. In any event, so long as there is a non-exclusive jurisdiction or an exclusive jurisdiction clause in favor of courts in the UK, whether it be exercisable by one party or all parties to the contract, that is sufficient, and a party does not need to seek permission to serve outside the jurisdiction. The second is if an Indian party or the foreign party is required under the contract to maintain a service agent in the UK. This has actually been a long-standing tradition, and one can at very low cost engage service agents in the UK and their only job would be to accept service of court documents on your behalf. And there are interesting issues that arise out of this. So for example, in one of my cases, I was representing the defendant, and my client had notified the other side, who was based in the UK, that their service agent contract had expired. About a year passed, and sure enough, as is typical, service was effected on the service agent in the UK. And so there was a fight before Mr. Justice Popplewell, now Lord Justice Popplewell. And really the point was the point of agency. If the agency does not exist between the service agent and the Indian client or the foreign party, then how can the court document be effectively served on the service agent? And the argument against was that if there is an obligation under the contract, that a service agent must be maintained throughout the term of the contract, but also beyond the term of the contract until such time that all obligations are fulfilled, then it is the foreign party's responsibility to continue to maintain the service agent in the UK. And Mr. Justice Popplewell thought that was the better of the argument on that day. And so those are the two exceptions for when one doesn't need to seek permission to serve outside the jurisdiction: service agent, and when there is a jurisdiction clause in favor of an English court. Now I'm moving on to the second without notice application that I said I would, which is permission to seek to serve by alternate means. So what happens is, once a party seeks permission to serve outside the jurisdiction, they must actually serve the Indian party or the foreign party outside the jurisdiction. And in most cases, including India and England, this is to be done in accordance with the Hague Convention on Service, because both India and the UK are signatories to the Hague Convention of Service. And India has appointed the Ministry of Law and Justice, New Delhi, to receive requests for service under the Hague Convention. So the UK would, the foreign process section in the UK would send the court documents to the Ministry of Law and Justice, New Delhi, and then the Ministry of Law and Justice would organize service domestically within India. So if a claimant is lucky, sometimes it only takes about 4 months to serve in accordance with the Hague Convention. If not, it could take 8 months, and many a times it takes longer. So the claimant in England gets impatient, all of us do, and then they make another application, which is also without notice application, to the court in England, seeking permission that they be allowed to serve the foreign defendant or the foreign party or the Indian party by alternate means, such as via email or via international courier such as DHL, etc. Unfortunately, this is an easy one to overturn, because on the return date, all one needs to do is turn up and say, no, simple delay or mere delay, as English courts have put it, is not sufficient to sort of execute service outside the Hague Convention. So there are two English court judgments. One is a High Court judgment called Marashen, and the other one is a Court of Appeal judgment called Goldas. And both of them basically uphold the exceptional circumstances test. So if you want to serve an Indian party or a Turkish party or any of the others that are signatories to the Hague Convention on Service, it must be in accordance with the treaty, because the international treaty should be respected. It's been signed by countries on an international level, and it must be respected. And therefore, it is only in exceptional circumstances that service outside of that arena, so service by alternate means via email or courier, can be granted. So those orders tend to be sort of easy to set aside at the return date. The third type of without notice application is a freezing order. And some courts, such as the High Court in England, the Commercial Court, or the DIFC Court in Dubai, are amenable to granting worldwide freezing injunctions. We've seen this recently in relation to an Indian case, which was Mr. Malia. So following the DRT judgment in India, a worldwide freezing injunction was successfully sought against Mr. Malia's assets in the UK. And a freezing order basically restrains a party from removing assets that are within the jurisdiction. But if it's a worldwide freezing order, it would also affect all assets outside the jurisdiction. It also restrains a party from dealing with assets, whether located within the jurisdiction or outside. And there are, so they tend to say an X amount of money is allowable for weekly expenses, and any business in ordinary course can be conducted, but nothing outside that. Now, there are, as one may imagine, various duties that a without notice applicant needs to abide by or follow. And this is necessary because of the simple principle that the court is reliant on the party that is before it. And since there is an absence of the other side, it's the duty of the party that is before the court to make full and frank disclosure to the court of everything in relation to law as well as fact, whether or not it is in their favor. So for example, it is their duty to draw the court's attention to various potential defenses that may be taken by the party that is not before the court. It's also their duty to, we've just spoken about the law in relation to permission to serve outside the jurisdiction. So often we can come back and say, well, they should have brought to the notice of an English court at a without notice hearing that the rule to serve outside the jurisdiction by alternate means is exceptional circumstances, and therefore permission to serve by email should not have been granted. So it's not just facts, it's not just potential defenses that a defendant may take, it's also the law. And there are some key principles that one may want to bear in mind as far as permission, as far as the duty of full and frank disclosure is concerned. So whether a matter, when deciding what to present to a judge at a without notice hearing, is material, is actually for the judge to decide and not for the party or their lawyers to decide. So it's always best to disclose everything and leave the decision for materiality to the judge. The applicant must also include matters that may be adverse to his case, as I've just mentioned, including potential defenses. And the applicant must disclose facts known to him, but also facts that could have been known had proper inquiries been made. The duty of full and frank disclosure is also a continuing duty. So this means that if a claimant has brought a without notice application today and before the matter is served or that order is served, the claimant goes off and initiates a proceeding, let's say at the DRT Chennai, which happened in one of my cases. It is a continuing duty for the claimant to return to the court and say, I'm still in the process of effecting the order of the court and serving the order of the court. But in the meantime, I've gone and invoked this parallel proceeding at the DRT in Chennai. And therefore, it is my duty to come back and inform the court to do so. So concealing, so this matter that I'm referring to is called PNB and Srinivasan. And in that matter, the Chief Master Marsh, and this was upheld by Chancellor Voss, said that permission that there was plainly a duty not just to bring the existence of the DRT proceedings to the attention of the court in England, but also to explain their scope and how they interrelated with the claim before the English court. On appeal, Chancellor Voss upheld this and further held that the failure to disclose the Indian proceedings was a serious breach, and that the claimant's culpability in relation to its duty of full and frank disclosure should be judged at a high level. In that matter, the claimant was out of time, and therefore once this order was set aside for breach of duty of full and frank disclosure, they could not bring those proceedings once again because limitation had passed. But the court decided that it was a policy principle of the court, and it was important for the integrity of the court that full and frank disclosure be made at without notice applications. I see that time is marching on, but David, I'm going to be as quick as I can. The consequences of a failure may be to set aside the order, or to set aside it but reinstate it and order that the claimant, even if they may have a better case on the merits or a good arguable case on the merits, that the claimant pay the defendant's costs for purposes of the return date. The next duty at a without notice application is also to provide an undertaking in damages. So any loss suffered by the respondent as a result of the without notice order that should not have been suffered is compensable in damages. And when seeking a without notice application, or when making an ex parte application, the applicant is therefore required to furnish an undertaking in damages to compensate the respondent if it is subsequently determined that the respondent should not have been brought within purposes of the jurisdiction, or the freezing injunction should not have been granted against it. And sometimes it's enough to just say, I, the applicant, undertake to pay the damages for the defendant or the respondent. But at other times, it's not just sufficient to make that statement, because it must be fortified by paying money into court or by providing some sort of guarantee, bank guarantee, etc. The next duty is to draft the terms of the order carefully. Now, this is slightly strange, and I found it strange when I moved from India to England, that whenever we make applications to the court in England, we draft the order as if we were going to win the case anyway. So we draft an order, and the order is attached to our application notices. In case of a without notice application, it's essential to draft the terms of the order carefully and specify a return date as soon as possible. There's also a duty to act promptly following permission to serve outside the jurisdiction, and that includes a duty to serve very promptly the application notice, court order, any evidence in support, but also the hearing note of the lawyers who were present at the without notice application. Again, this is something that I found odd, because I thought maybe this should be protected by legal professional privilege, or at least it should be protected by some sort of confidentiality. I mean, when I'm making notes in court for my client or for my instructing solicitors, I don't want the other side to see them. But it's important to remember that this is a duty, and any notes taken by in most cases, the solicitors in this instance at the ex parte hearing have also to be disclosed and served on the other side. At the return date, and this is the last of my headings before I hand over to David, the defendant may make an application to set aside. And an application to set aside is a complete rehearing of issues, and a court need not be influenced by whatever the order was at the ex parte hearing. And in these cases, if you're representing the defendant, I've found in my experience that there are two ways that are easy to have the order set aside. I mean, I say easy, it depends on every case, but mostly you want to come back to the court and say, look, I'm the defendant, but I'm here to make an application to set aside this ex parte order because the claimant never had a good arguable case. And I had the better of the argument, or I had the plausible evidential basis on the documents that were presented to the court. So that's first, or secondly, breach of full and frank disclosure. So one of these two tends to work, at the return date. And David, I think this is when I hand over to you.
Karishma, thank you very much indeed for really that tour of without notice applications, what used to be called ex parte applications in England. There used to be a creature, I suppose it still exists in English court procedure, which in fact was called an application made ex parte on notice. And this was, for example, what one did at the end of a case when you had judgment, and if you wanted a freezing injunction in support of the judgment that you had, and the other side was present in court, but they would say, oh, look, we don't know what judgment's coming down or whatever. And on the basis that they were present in court, but you had the burden of standing everything up, you would tell them that you were going to apply, but that they didn't really have to appear at that hearing. That was called ex parte on notice. That, of course, led to the logical absurdity, which was pointed out by Lord Mustall, not by me, by Lord Mustall at the time that we moved away from Latin in the English courts, that we ended up with a creature called an application made without notice on notice, which appealed to his sense of the ridiculous and mine. Anyway, one of the types of application that is frequently made, generally made without notice on its first application, is an anti-suit injunction. I just want to talk about these for 10 minutes or so. Just thinking conceptually, what we're dealing with here is a circumstance where there are two or more competing jurisdictions in which a case may be brought and heard. A party may take one of two different approaches. They may, first of all, say the English court is in fact the inappropriate jurisdiction. That isn't an application for an injunction. That will be an application to the English court to stay proceedings brought before it. In England, for example, if there is an arbitration agreement that provides for arbitration in India or in Hong Kong or in Singapore or wherever, then if litigation is brought in England in breach of that, you can apply under Section 9 of the Arbitration Act 1996, and the English courts will stay those proceedings. That's off to one side. What we're looking at here is the circumstance where what is asserted is that the non-English proceedings are the inappropriate proceedings, and the support of the English courts is sought so as to support proceedings in England. Those proceedings can in fact be litigation or arbitration. And the English courts will in fact issue injunctions to restrain proceedings in support of either arbitration in England or litigation in England. And there can be, again, another conceptual split. You may be dealing with a circumstance where there is what's sometimes called competing or alternative forums, or there may be a circumstance which I've seen described as a single forum case where there is really only one appropriate place to go. Most of the time, what we will be dealing with in terms of this seminar and commercial practice is a single forum case. Looking at multiple forum cases where there is in fact the possibility that, for example, litigation in England might be appropriate or litigation in India might be appropriate, then a party applying to the English courts would have to go through a number of tests, but generally also show that the litigation outside England, not only was England the natural forum for the proceedings, but also the proceeding outside England would be vexatious or oppressive. And that gives a whole set of problems to a party seeking to get an injunction in those circumstances. And it tends to be a more unusual circumstance. The more common circumstance, at least in commercial practice, is where there is an infringement of a legal or equitable right, and where the legal or equitable right that is infringed is an exclusive jurisdiction clause. And that exclusive jurisdiction clause may be in favor of English litigation. So the sort of clause that I'm used to seeing and Karishma is used to seeing, any dispute or difference will be subject to the exclusive jurisdiction of the English courts. Alternatively, the other common exclusive jurisdiction clause that you will see is an arbitration clause where the seat is in London. And in those circumstances, the analysis is that that confers exclusive jurisdiction on the English, on the arbitration in England, and the English courts can be invoked in support of that. The jurisdiction that is invoked is in fact under the general jurisdiction of the English courts under Section 37 of the Senior Courts Act to grant injunctions. That's a general looking jurisdiction, but it gives the English court power to grant anti-suit injunctions. And the principles are reasonably well established. They start off with dicta from, if you look at the academic discussions, the jurisdiction to grant anti-suit injunctions goes back into the 19th and 18th centuries. But people very often start with a case, the Angelic Grace, in which Lord Justice Millett, became Lord Millett, said that the court should lay down the ritual incantation that the jurisdiction, namely the jurisdiction to injunct proceedings, is a jurisdiction which should only be exercised sparingly and with great caution. And in fact, you now reach the position that once a party shows that there is in fact an exclusive jurisdiction clause, in particular an arbitration clause, the English courts will generally grant an injunction to support those proceedings. The party seeking an arbitration, an anti-suit injunction in support of an arbitration or in support of litigation, bears a burden of establishing to a high degree of probability that there is an arbitration agreement. And that's from Transfield Shipping and Sheepinge in Farr by Mr. Justice Clark, as he was. And that's not just an arguable case that there is an arbitration agreement, it is to a high degree of probability. And that makes sense. You're generally going to be relying on a document that has an arbitration agreement, and you're going to then have to show to a reasonable degree of probability not only that the arbitration agreement exists, but that the dispute falls within its jurisdiction, or the jurisdiction of a tribunal constituted under that clause. Once that burden is satisfied, that effectively reverses the burden of proof, and the other party must then show a strong reason why the arbitration agreement should be upheld, and what was referred to by Mr. Justice Cook in a case called Sul America as the prima facie entitlement to an injunction should not be observed. And so you can see when making an application, you'll very often go ex parte for the reasons that Karishma identified, that you may want to avoid something being done to frustrate the anti-suit injunction. And one of the things that some people cite as not frustrating the anti-suit injunction is an anti-suit injunction in some other court or jurisdiction. But at that point, you need to deploy evidence of the dispute, of the arbitration clause, discharge the burden that there is a high degree of probability that there is an arbitration clause, show that the claim comes within the ambit of the arbitration clause, and at that point you have a prima facie entitlement. And the other party on a return will have to show a strong reason why that should not be observed, or will have to argue that in fact the arbitration agreement, if we're dealing with an arbitration agreement in this circumstance, doesn't apply to the dispute. One of the other grounds for resisting or not granting an anti-suit injunction is delay. And you'll be familiar with delay. An injunction, of course, is an equitable form of equitable relief. You'll be familiar with the idea that delay in leches can act as a defense to an injunction. And there is a view that delay will preclude an application for an anti-suit injunction. There's another reason why delay will preclude an anti-suit injunction, and that is because the injunction in an anti-suit injunction is made against the party bringing the proceedings. It's not made against the other court or arbitral tribunal. And it's not brought against the other court. It's not made against the other court for reasons of judicial comity. And those of us who obtain anti-suit injunctions, or if you read the judgments in relation to anti-suit injunctions, you will see this almost ritual incantation, either at the beginning or the end of the judgment. It never quite worked out whether it varies from judge to judge, but you will see this ritual incantation that there is no suggestion that there is any infringement of comity, that there is no disrespect to the other court, and of course the other court is not being injuncted itself. The injunction is directed towards the party, not to bring proceedings or to refrain from continuing with those proceedings or prosecuting them. And the delay and the interrelationship between delay and comity is why delay can in fact preclude an anti-suit injunction. Because if you have proceeded and participated with proceedings in some other court and let that other court go on to interim orders, judgments, that sort of idea, then in fact suddenly saying to a party, well, stop those proceedings, the view is that that might itself infringe concepts of comity. So if you're going to apply for an anti-suit injunction to restrain a party from commencing or proceeding with proceedings in somewhere other than England, then you may need to make sure that you do that at the very outset of those proceedings. And indeed, the idea of comity goes to the fact that there needn't be any suggestion, not even need there be no suggestion that there is anything, any criticism of the non-English court. In fact, you can, I have in the past cited support of the other court as a reason for granting an anti-suit injunction. I acted in a case in which a party commenced proceedings in the High Court in Calcutta in breach of an arbitration clause, which provided for arbitration in London. We obtained an anti-suit injunction, although at first instance the Calcutta court had stayed its proceedings. There was a concern that the other party would seek to appeal, but we actually applied successfully to the English court for an injunction, one on the basis that there was an arbitration agreement and so we were entitled to an anti-suit injunction, but secondly that in fact the view of the English court may be of some support or assistance to the view already articulated by the court in Calcutta in maintaining the stay of its proceedings that it had advanced. One interesting case that in the last couple of minutes may be worth touching on is a case Enka Insat Vesanya, sorry, not wrong case. Vansanaye, which is a Russian case against Chubb Insurance Company. Chubb Insurance at the moment are giving English arbitration jurisprudence a number of cases. Those of you who have heard of the Halliburton case in the Supreme Court, on which we're waiting for judgment, may know that that also involves Chubb. But Chubb involved proceedings in Moscow before the Moscow Arbitrage Court. The proceedings were started in, I think, about 2017. They weren't proceeded with because, in fact, Chubb's pleadings were said to be defective. But eventually, in 2019, the Moscow Arbitrage Court allowed the proceedings to commence. The other side then sought an anti-suit injunction at that point. And one of the things that was said was, hold on, you waited 2 years, you waited too long. The English court said, no, in fact, the proceedings in the arbitrage court weren't going anywhere for those first 2 years because it was said that the proceedings were defective. So the application was made promptly. Once the application was accepted by the arbitrage court, so there was no delay there. But also the English court at first instance considered issues of forum non-convenience, and in fact used forum non-convenience as a primary test or preliminary test in testing the anti-suit injunction, and in fact at first instance declined to make an anti-suit injunction because it said the Moscow court was more convenient forum, and the Court of Appeal said no. If there is an exclusive jurisdiction clause and an arbitration clause satisfied that, then questions of forum non-convenience didn't fall to be considered by the English court in making an anti-suit injunction in support of the arbitration agreement, which was the exclusive jurisdiction clause which was being considered. So with that, one of the kinds of without notice applications that you can make, and it is a powerful weapon. We could have separate discussions as to how you enforce or the consequences of anti-suit injunctions, but they tend to be powerful weapons when constituting proceedings where there is an arbitration in London. And finally, for those who may wonder or who may have read some English anti-suit injunction law already, just a quick reminder, you don't simply need to have an anti-suit injunction if you're claimant to stop defensive proceedings, or if there really are proceedings. A party is perfectly entitled. This is an authority called Uska Kazmenesgorsk. A party is perfectly entitled to say, I'm the defendant, I don't have a counterclaim. I don't particularly want to be sued, but if I'm going to be sued somewhere, I want to be sued where I've agreed to be sued rather than somewhere else. And in those circumstances, even that rather vague submission or rather vague position, I don't want to be sued, but if I'm going to be sued, I want to be sued here, is perfectly permissible to be supported by an anti-suit injunction. I think, Karishma, though, that covers what we were going to discuss in relation to ex parte proceedings and anti-suit proceedings. What we now come on to is a little bit of discussion of the English bar rather than English solicitors and the role of law firms. And we thought that rather than talking at you, we would try and make this as interactive as we could. And so we've in fact written a few polls. So in the first instance, can I ask, this works, this will also tell you my IT skills. Hopefully you'll see a poll coming up on your screen just now. And if you can answer that, and then Karishma will start talking about the English bar. I should say these polls are anonymous, so far as I know, so you needn't feel shy about answering. We'll not be able to identify who you are or how you answered. Well, while you're carrying on with that poll, I'll just say I started by way of my background. I'm a, as I was introduced at the beginning by Price, I'm a Queen's Counsel at 39 Essex Chambers. I came to the bar in 2011, having been a partner in one of the London law firms, now one of the international law firms, I think probably described, which at that time was Herbert Smith, now Herbert Smith Freehills. I was one of the individuals at Herbert Smith who did international arbitration. I did my own advocacy. I did a little bit of work as an arbitrator. I moved to the bar, which let me move away from my role principally as a solicitor, and my focus now splits between work as an advocate in cases, and I also sit quite a significant amount as an arbitrator. I became Queen's Counsel, what you call taking a silk robe, I think, in 2019. I've practiced throughout my time at 39, where I practice in our commercial and construction group, which is a group of about, I would guess, between 30 and 40 counsel, which we'll come on to, which is about 10 silks and 30 juniors. And I'm pleased to say that one of our juniors is Karishma.
David, thank you. Thank you for the cue. And thank you also, I should add, to Rupa, who's on this call, who prompted us to just talk about life at the English bar. I didn't think anybody would be interested, but apparently people are. So thank you very much for asking us to just chat about it. I moved to England about 11 years ago and have been at the English bar practicing mainly commercial litigation and international arbitration. And I remember one of my colleagues from Chambers in Mumbai. So I was at Chambers of Zal and Therugina, but at the time he was just about getting out of the chambers of Mr. Janak Dwarkadas, senior counsel, superstar. And one of our colleagues moved to Delhi and said, goodness, Karishma, you know, at the Bombay Bar, we have excellent commercial work, but when you move to Delhi, you get work from all over the country. And I felt like that when I moved to London, because you just suddenly get work from all over the world. And of course, I feel incredibly lucky to be at 39 Essex, because it's an incredibly commercial, rather not commercial, international set. We've got offices in Singapore and Kuala Lumpur. But what was music to my ears, which prompted me to join, is that they come to India 4 times a year. And I don't know any other barrister set that does that. And as one can imagine, some of them are stuffy British barrister sets, but thankfully we are not. And hopefully you got that taste when we spoke to you. I thought I'd just speak to you very briefly about just the differences that I found as a counsel at the Bombay High Court, where I worked for 6 years before moving to London in 2009. And that's mainly in the style of advocacy. I think the way one conducts themselves in court in India is completely different. We have the results.
I'll let you carry on. I'll just let people watch that in the corner.
So I think the manner in which one conducts themselves in court in London is completely different from the way I used to conduct myself in court in Mumbai. For one, it's not a busy courtroom. So in the commercial court, which is where I mostly appear, it's just my side, it's the other side, and it's the judge, and that's it. The hearing may have been listed to start at 10 or 10:30 a.m., which it does. If it was listed to go on for the whole week, it does. And nobody else bothers to come in. There isn't the crowd, which I sort of miss, because I miss the drama of being at the back of the courtroom in Mumbai at the High Court, and when my matter is calling out, you know, to try to push and try to get to the front just to be able to be seen and heard. So it's quite different. And I was once, I did what is called marshalling with a judge of the Court of Appeal, which is the equivalent of the division bench in India. And I was called during a busy week. And during this busy week, the judge had 3 matters on board during the whole week, 2 for 2 hours each and 1 for 45 minutes, and 2 full reading days. Now that's a very different style of working and manner of working from India. And that also means that one has to be extremely prepared, and there are no surprises in court. So it's not like you can just turn up to court with a dozen or so judgments that you wouldn't have shared with the other side. In fact, you can't even turn up to court without having previously disclosed what your arguments are. So we have a system called skeleton arguments, and these are, I think the closest Indian equivalent would be written submissions, and it's compulsory that these are exchanged a few days before the hearing with the other side as well as the court. So no surprises. The other side knows exactly what you're going to say. The court knows what they're going to say. And the skeleton arguments also need to set out what the reading list is, or essential reading for the judge. And hopefully the judge would have done that before coming into court. So really quite different. And style of drafting also is I think that is the biggest difference that I found, because I remember being a junior at the Bombay High Court and being praised for my drafting skills, and therefore I thought I must have good drafting skills, because others have told me that I have good drafting skills. And then I moved to London, and while I was requalifying, this is about a decade ago, and I was still working at a law firm, requalifying at the English bar, and I drafted this, this document, and sent it off to the head of litigation at Flatgate. And he came back promptly to my desk and said, "But Karishma, this is not even English." So that's where I had to sort of restart. But hopefully David will be able to tell you some more. David, if you can perhaps tell them about a clerk's room, which is also different, and contributions to chambers, which also is rather different from the Indian system.
Yes, I mean, it's, I'm going to launch another poll while I'm at it. I think everyone's seen the background, which is principally a law firm background. We've got some private counsel, and we've got, I think, one or two in-house lawyers. Insofar as I'm now going to talk about in English barristers' chambers and the clerk's room, just talking about using counsel, and this is both Indian counsel and non-Indian counsel. So I'll launch this poll, and I'll let you get on with this. Yes, I mean, an English barristers' chambers, I think, is something which, if you grow up with them, which is what I have done as an English solicitor, and which I'm now used to as an English barrister, makes perfect sense. But if you don't actually know what an English barrister's chamber is like, it seems almost incomprehensible. I suspect many of my Indian friends tend to understand what a barrister's chambers is, because it looks a bit like what you have as a chambers in India. We had, I think, the position in England that barristers' chambers were the chambers of an individual. And that's still, in fact, reflected in the fact that the head of chambers or heads of chambers, it's perfectly proper to refer to a chambers as the chambers of X, and you refer to head of chambers. But in fact, chambers are now much, much bigger than that. We have far more than 40 members, all told, doing a variety of practice areas. We've got about 40 commercial and construction practitioners, as I said. We are all, in exactly the same way as you would be at the Indian bar, self-employed individuals. So we don't share profits. We don't share fees. What we share is expenses. And so Karishma and I don't share profits. Our income is unrelated to each other. Karishma can go away and have her fantastic and fabulously remunerative practice, and I just have to watch and be jealous. What we do share are expenses, and the ways in which expenses are shared varies from chambers to chambers. In fact, probably as many ways to share expenses as there are chambers. But there is generally a combination within chambers of some sort of rent for a room, which some chambers impose, which a member will pay every month, and then a contribution towards chambers expenses, which can be a fixed contribution, it can be a varying contribution. In fact, at 39, the way we work is we simply rely on variable contributions by reference to our income. So of every £1,000 that I make, a proportion of that goes to chambers. And from that, chambers seeks to meet its expenses, so rent, the employment of individuals, in particular individuals called clerks, who we'll come on to, light, heat, all of those things. So there is an incentive for members of chambers to gather together, because you get economies of scale. So for example, chambers as a large chambers has an IT department of 3 full-time individuals and a couple of others who help out. And that means that we have, we think, better IT facilities than we might otherwise have. So we gather together on that basis. We get economies of reputation. So hopefully you hear Karishma's wisdom and erudition, and you think that maybe it would be a good idea to instruct me if you need an English silk. You listen to me and you decide that it would be a good idea to instruct Karishma. We work synergistically in that sense. But in fact, because we are self-employed individuals, our strict ethical position is that we can act against each other. So if you want, you can instruct Karishma to act against me. That's fine. There's no ethical issue. And we're not sharing fees or anything on that basis. That works perfectly well in the English High Court circumstance, and it works perfectly well in arbitrations where parties understand what's going on. It can be difficult, I confess, in international arbitrations where non-English parties who don't know how the English bar is established wonder what on earth is going on when they see members from the same barristers' chambers acting opposite each other. It can also operate in circumstances where members are arbitrators. I have had members of chambers in front of me when I've been an arbitrator. I have been in front of a member of chambers. In fact, it's sometimes a more rigorous and more difficult circumstance because you tend to give your colleague from chambers a harder time than you might give someone who you've never come across before. But again, that is a circumstance which works perfectly well from an ethic and a deontological perspective, but which non-English parties who don't understand the English bar sometimes wonder what is happening. Now, just turning to the poll, what's interesting for India-related work, you appear to use independent counsel for opinions and advice. Nobody appears to use Indian counsel for drafting pleadings. Now, whether that's caught up with the fact that...
David, are you able to share the results of the second poll?
Yeah, sorry, I'm just looking for that. There you are. And this is quite interesting because I think this reflects an use of the bar by you in India, which would also reflect the position if you were in England. Opinions and advice, about 20% of you, 40% for advocacy only, 40% for opinions, advice, pleadings, and advocacy. And that probably reflects the idea that that's a sort of service that we give as members of the English bar: opinions, pleadings based on that, and then advocacy following on for that. Counsel for work outside India, the majority there, interestingly, opinions and advice, but again, a group for opinions, advice, and pleadings as well. And then the multiple choice question: would you consider instructing the following? Indian counsel on international matters, 53%, so that I assume would be using your regular Indian counsel. Law firms outside India, 40%. Counsel outside India through a law firm, 73%. And then counsel outside India directly, 60%. I find that quite interesting because I obviously get instructed, in Karishma's experiences, she will get instructed by parties in India. And some of that work will come directly, some of that work will come through a law firm. Karishma, I don't know your view on that poll.
David, sorry, I've lost the poll, but I would agree. Sorry about that, but I would agree with you that that yes, the majority of my instructions would come directly from an Indian law firm or an Indian company, and some of it would come via an English law firm, but certainly not most of it, because most of it would come directly from an Indian law firm or company. Are we doing the third poll at all? But before we'll do
the third poll. We have a third poll for you, which is I think a bit of fun if I can manage to get it to work. Working with counsel, and yes, this is just looking at this, for those of you who've worked with English counsel, you may know these, but these pick up, first of all, whether you like acting as junior to outside counsel, and we can probably guess some of the results of these. Do you know you can instruct barristers directly? Well, those of you who say that you've done so clearly know that. Then the question, do barristers charge how we charge? Questions about how we use our diary, and then questions about, do you know what a barrister's clerk does? And I'll just launch that. So hopefully you can see that. And these questions reflect how we aim to work as English barristers. Karishma, I don't know what you felt was most interesting of these when you started working at the English bar.
I think blocking out a diary for a case. I think Indian counsels just are not in the habit of doing that. They're in the habit of sort of overbooking and having multiple matters on board every day. And in England, there was no chance. I mean, it's against our professional ethics, and we all have to study our professional ethics before we are called to the bar in England, and learn sort of that once you have something in the diary, that's it. You have to prepare for it, and you have to turn up without any reminders, and you certainly cannot double book, which is a bit unheard of actually in India, and certainly for the senior counsels in India. David, they would really be quite attracted to the fact that they may be instructing you as a QC, and that you will be prepared and turn up, and you would have read all of your papers.
Yes, well,
you can't charge in lakhs and crores, David. I think that would be the only difference.
I might like to charge in crores and lakhs, but no, sadly, yes, I mean, we don't double book, and diary management is a significant part, which actually some of you have got in relation to what the barrister's clerk do. Is significantly to manage our diary, but that's not just putting cases into our diary. That is putting in preparation time, dealing with preparation time, talking to the client and to the barrister about what time is necessary for preparation, and then making sure that we're doing it. I will get emails, in fact, on a daily basis as to what I'm supposed to be doing the following day. And that will, one, serve as a diary reminder for me. Karishma will get the same emails from the clerks. But also then the clerks will sometimes say to me, look, you've got this coming up in a week's time. Are you okay in terms of prep and other things? And do you have that at the front of your mind? And so that is something that we do, and the clerks help us with enormously. I think what's interesting. You like acting as juniors, and one of the things that I see is very frequently working with law firms, whether London law firms or law firms outside London, where people like to work with us, not simply sending us papers and saying, please advise, please draft, but a degree of liaison. And that's a very common experience in terms of the way that London law firms work, which then flows over into our overall approach. In terms of our charges, yes, you're right. 40%. Actually, interestingly, only 47% of you know that barristers will do any mixture of fee arrangements that client wishes to use and agree. This was a slightly cheat question, because in fact, we will charge on any of the bases that are there. We can charge on a fixed hourly rate. We can perfectly well charge in a lump sum per hearing or for agreed fees. In fact, this is one of the things that the clerks are very, very good at discussing and negotiating. We are entitled to charge a reduced fee with an uplift for success, what's called a conditional fee. And that is proper at the English bar. Now, we can do that. There are issues with that and the way in which that works, but we can do it. We can also, in fact, do a conditional fee arrangement, a percentage of the amount claimed. There are difficulties with our agreeing that, which technicalities that I won't go into on this call, but we can actually agree a fee on that basis. So in fact, the proper answer, those of you who were in the 47%, you can feel very smug. You're right. We can charge any of the fee arrangements that are suitable. And certainly as I look, I don't actually have a conditional or contingent fee basis, and contingent fees, so a reduced fee with an uplift, tends to be used in particular kinds of English domestic litigation. But certainly fixed hourly rates, lump sums per hearing, lump sums per stage, are very commonly used. I suspect that's the case for you, Karishma.
Yes, quite so. So I wouldn't do a conditional fee arrangement, but I would be happy to be flexible, because I think it's just important to be cooperative and do not only what is in the best interest of the client, but also what the client is comfortable with. And that would mean, you know, a flexibility in terms of fee structures. And thankfully for us, we're, I mean, I used to do it perhaps in my initial days at the bar, but learned very quickly that that's the job or the profile for a practice manager or a clerk. And so now those who are my practice managers, so I have Mark and Nikki as my practice managers, and that's what they would do. And they would just be equally accommodative.
And that really is the point.
Are we able to see the third poll results?
Oh, sorry, that's me. I keep forgetting to share these. Share results. So there you can all see. Sorry, I've been keeping these secret. Thank you, Karishma. So there you can see the results of the third poll on working with the bar. And then, in fact, what's interesting at the bottom in terms of, to an extent, Karishma and I are half of Chambers' offering, which is advocacy, advice. But the commercial manifestation of a Chambers in London is through the clerks' room. Karishma referred to as the practice managers. And what's interesting, of course, we're talking about barristers' clerks. We're not talking about legally qualified clerks. A lot of clerks join us when they're 16 or 18. Those of you who know London and Fleet Street will know that between 9 and 10 o'clock in the morning, you see well-dressed teenagers walking up and down Fleet Street to the Royal Courts of Justice with sack barrows full of papers. Well, those are junior clerks, and they're learning their trade. And the phrase is, in fact, that they're learning their trade on the barrows. And then they move on to dealing with clients, relationships with law firms, relationships with solicitors, relationships with the courts, until eventually what they're doing is running our practices. And that's relevant because a lot of you have there that they run our diary. Well, that's right. They will run our diary, but they'll run our diary not just to the extent of keeping our diary like a PA. The clerks will fix hearing dates and hearing times in London. I wouldn't try and fix a hearing date in London. The court would think I was mad if I tried to do so. But the clerks will liaise with the court clerks, the judge's clerk, and also the clerks for counsel on the other side from me, so as to fix a hearing date and a time at everyone's convenience. So the clerks do that. They manage our diaries, but they don't just record our diaries. They actively manage our diaries. They make sure, the clerks will say, look, you've had an inquiry for this hearing, but you're prepping for a hearing the following week. I don't think you can probably do this. They'll have that kind of conversation with us. It's interesting that that only 29% of you say to agree and manage fees. I tend to take a greater interest in the agreement and management of fees because of my history as a law firm partner. There are members of Chambers who actually do not take any part in fixing their fees or managing their fees. They just do the work and they leave everything to the clerks. And so, in fact, the agree and manage fees is probably a higher proportion than managing the barrister's diary, because those of us who do arbitration, for example, we do, particularly when we sit as arbitrators, we end up managing our own diaries because we end up fixing hearings for that. But agreeing and managing fees is every bit as high as managing the barrister's diary. To be available as a point of call to clients on possible cases, yes, you've got that. But again, that is important. There are times when Karishma and I, we will be in court, we will be in con, we'll be giving advice. The clerks are there for you to email or phone or speak to, either on an existing case, a possible case. If you suddenly need advice sooner than had been agreed, you phone the clerks. Much better to phone the clerks than me. They will know what my diary is like. They'll tell me what I need to do. So the clerks are there as a resource for you in terms of your interaction with us. And then to recommend different barristers if a particular barrister is unavailable or unsuitable. And that is both on a whole case or just for part of a case. If one of you were to instruct me leading Karishma, and then in fact something arose so that you wanted me to carry on for the rest of the case, but there was one hearing and I was in trial on a different case, the barristers would recommend someone. And they would recommend someone with a better knowledge of that other person's diary than Karishma would have. Or if Karishma was unavailable, similarly, they would recommend someone. But in fact, the clerks are very, very good at maintaining relationships. And for those of you who have met us when we've been in India recently, you'll know that actually one of our clerks, Mark Winrow, comes down to India when I travel to India to speak at conferences or to meet clients. And Mark's role is to build relationships. And one of the things that destroys relationships is making recommendations for somebody who takes on something that they can't do. So in fact, if you phone, let's take an example. We are not, I don't think Karishma is about to throw up her hands in horror. We are not a wet shipping set. I would not pretend to do a wet shipping case. I have no idea what they do in casualty and collision cases. So if you phoned up, first of all, the clerk would say, no, David, Karishma don't do wet shipping work. Secondly, if you needed a wet shipping barrister, they would help you find one. Not to phone around and actually negotiate someone's diary, but they would say, actually the place where you might want to look is X or Y or Z. So for those of you who've either used the English bar a little bit or English chambers a little bit, or who are beginning to come across us with clerks coming down with Karishma or me, or coming up to London, meeting the clerks are important individuals to get to know, because in fact they can act as an enormous resource for you. Now I can see Pras has come on, which presumably means that as usual I'm running out of time. I just wonder, Pras, whether Karishma has any observations on clerks and clerking, because I suspect it is one of the changes again from the Bombay bar.
Yes, completely, but in a completely different way. I mean, both. I was a article clerk at a law firm called Vadya Gandhi in Mumbai, and I think I learned a lot from my clerks, just because they knew that I would go to court at the drop of a hat, and they were willing, when I was a baby barrister or a baby counsel at that time, to stand behind me in court and just give me that comfort. And they would whisper into my ears things that I should say. For example, when the judge asked me, questions that I would just look at him in horror about. And that was a good system. I think they were excellent. They could have been lawyers, and many of them have done really well for themselves. And completely different though, the system, the clerk system. from England, which David has just spoken to you about. And with that, Pras, if I may hand over to you.
Thank you.
May I just say thank you very much to all the, there are so many known faces who have attended, some of whom are still on. And I just thank you very much for your time and for attending this talk.
Yes, I'm conscious that it's a Friday evening, so thank you.
There is one question to David and one question to Karishma, if you can quickly answer that. Karishma, they're asking you to give the reference of the case, and David, you have a question also.
I've answered that, but I can circulate the citations a bit later.
Yeah,
if okay.
Very well.
But they should be able to find it because I've put down the names of the judges as well.
Very good. All right.
Yeah.
Yeah.
Yes. In fact, ironically, it did involve the Calcutta port, but it wasn't Calcutta and Louis Dreyfus. Which the question I'd been asked is whether I'm referring to an anti-suit that arose in the context of an anti-arbitration injunction in international investment arbitration. It's not. It's actually it was a private case between two private entities, although it did arise from the concession for the development of the Calcutta port in sort of around 2010 and onwards.
Thank you. Ladies and gentlemen, thank you very much for being with us. And thank you, David and Karishma. I'm reminded of my very favorite author. When I was a law student, I used to read a lot of Perry Mason's stories. And Perry Mason used to use that expression, practicing legal medicine. And today, you both have done precisely that. You have administered capsules of worldly wisdom, and Karishma has shared her experience of becoming a barrister, truly inspirational. I'm sure it was not a rosy path for her, and she had to navigate choppy waters before she got to London and established herself. But we, as an Indian legal community, are very proud of her. And she can be a role model to many of the participants here who aspire to become barristers. And thank you, David, for giving an insight into how the chamber works. And it has been a very revelation for me, at least, as to how things actually work. It's such a well-oiled machinery. And all of you sort of, it doesn't just say two to tango, I think many to tango, and absolutely wonderful. I think it's a very heartening thing and very comforting for the client group. And we look forward to staying in touch with you and looking forward to having you for another session in due course of time. Thank you very much and have a lovely weekend, all of you. Thank you so much. Thank you.
Thank you. It's been a real pleasure.
Thank you.
Thank you.